Now, sir, good evening. इंडियन कॉन्ट्रैक्ट एक्ट से रिलेटेड कुछ इंपॉर्टेंट क्वेश्चंस फॉर योर नवंबर 2019 एग्ज़ाम लॉ। इंडियन कॉन्ट्रैक्ट एक्ट बहुत बड़ा पार्ट है और इससे बेसिकली 24 मार्क्स तक का भी पूछता है 24 मार्क्स तक का आता है। तो ये ज़्यादा बड़ा और इससे केस लॉस भी बहुत आते हैं और यू नीड टू बी थॉरो विद दिस पर्टिकुलर एक्ट। ना सबसे पहले कॉन्ट्रैक्ट में सबसे इम्पोर्टेंट क्या है सर जी? आपके लिए इम्पोर्टेंट है सबसे पहले रूल्स रिलेटिंग टू ऑफ़र से रिलेटेड जो रूल्स हैं उनको थोड़ा ध्यान रखो, क्योंकि उनसे रिलेटेड केस लॉज आ सकते हैं। तो रूल्स क्या क्या आपने को भी पता है। एन ऑफ़र मस्ट बी डिस्टिंग्विश्ड फ्रॉम इन्विटेशन टू ऑफ़र, इससे केस लॉ आ सकता है। दूसरा आपके लिए सर जी, द टर्म्स ऑफ द ऑफ़र मस्ट बी सर्टेन, डेफिनेट एंड शुड नॉट बी वेग। तो ये अपने को पता होना चाहिए। एन ऑफ़र में भी कंडीशनल, that an offer must be made with a view to obtain the consent of the offeree. An offer should not contain the term or condition the non-compliance of which would lead to acceptance, तो वो भी। इसके बाद mere statement of price is not an offer, बोल के कुछ नहीं होता उसमें। an offer में भी general और specific, express or implied. So there are certain rules which you need to remember and should not be vague, remember that also. Now, difference between void, illegal and voidable offer, that is important. Void, voidable and illegal. And इसमें ध्यान रखना, illegal में all collateral contracts are also void, but in case of void contracts all collateral agreements may be valid. तो वो valid हो सकता है, but illegal में वो हमेशा void होता है। Illegal is forbidden by law, void is not forbidden by law. And all void contracts are not illegal, but all illegal contracts are always void. ये सब थोड़ा सा ध्यान रखना तुम लोग को। And voidable contract which can only happen when there is absence of free consent, which is enforceable at the option of one or more parties but not at the option of other or others, is known as voidable contract. So remember these things. And void contract which ceases to be enforceable by law becomes void when it ceases to be enforceable by law. So these are the things, remember that is important. Then coercion and undue influence is very important, the difference between them and the basic characteristics of that. Coercion, threatening or committing any person to enter into a contract, is basically coercion. Threat to commit suicide amounts to coercion. There is some kind of a physical pressure on the other party. Even the parties who are not entering the contract, a stranger can also exercise coercion, so remember that also. And undue influence, there must be some kind of a the two parties who are entering into the contract, one is at a higher bargaining power and he is in such a position that he can dominate the will of the other party, and there exists some kind of a fiduciary relationship between the parties so that he is in a position to dominate your will, and if he uses that position to take an undue advantage over the other, in that case undue influence occurs and the contract becomes voidable at the option of the person who has suffered or the aggrieved party, and there must be a real and apparent authority. Examples are, there are many: master, servant, landlord, tenant, husband, wife, teacher, student, solicitor, client. There can be many, doctor, patient. So there can be many examples for this. There has to be some kind of fiduciary relation, the relationship of trust and confidence, because of which you repose the faith on the other party. That helps you. Now, next, exceptions to consideration, section 25. No consideration, no contract. Yes, the statement is valid. If there is no consideration, the contract is not valid. For a valid contract to take place, there must be a consideration between the parties. It may be adequate or inadequate, but it has to be real. That is what it is all about. But in some cases, even if there is an absence of consideration, the contract is valid. And these cases are being covered under section 25 as enumerated below or discussed below. Natural love and affection, compensation for past voluntary services, completed gift, creation of agency, gratuitous bailment, then succession and inheritance, then you have got charity. In all these cases, basically there is no need that a payment of time barred debt. All these things are covered under exceptions. Then you have got this is very important, Discharge of a contract. How a contract is being discharged: by performance, by mutual agreement, by breach, by lapse of time, by operation of law, insolvency, by remission when the other party remits, by subrogation, by basically taking a higher right and the lower right is being forego. In all these cases, the contract is basically being discharged by lapse of time and all these cases. Novation and alteration. The difference between novation and alteration is important. A new contract is being formed in place of an older one. It leads to novation. When the same contract continues, it becomes alteration. Only the terms and conditions are changed. The parties and all those elements remain same. It leads to alteration. The same contract continues. In case of novation, a new contract comes into existence. Supervening impossibility, I think a case law is going to come. You need to understand supervening impossibility, that when a contract cannot be performed due to operation of law or by an act of God which is not in the control of the parties to the contract, in that case the contract suffers from supervening impossibility and it becomes void, and the parties are not liable for any kind of damages. But in some cases there is no supervening impossibility. When there is a strike or lockout in your factory, it doesn't lead to supervening impossibility. In that case you are liable. Remember this thing: strike and lockout are not covered under supervening impossibility. So if the supervening impossibility exists at the time of making the contract or before it, then the contract is void ab initio. If it occurs later, at a later stage, it becomes void from the date the supervening impossibility occurs. That is what. Now, breach important hai. Breach, basically non-performance of a contract by one party, is known as breach. It can occur at any time. When the breach occurs on the date of performance of the contract, it is known as actual breach of contract. And when it happens before the actual date by the conduct of the defaulting party, we say it's an anticipatory breach of contract. In case of actual breach of contract, the aggrieved party can sue, has got many rights. He can rescind the contract. First of all, he can sue for damages, interest and injunction, quantum merit and specific performance. Specific performance cannot be ordered when the contract is based on personal attribute or quality of the other party. Otherwise, specific performance can be ordered if the court feels that there is a hardship. If compensation in money is ordered, then it can order for specific performance. Quantum merit, as much as you earn is quantum merit. You will get the remuneration as per the work done by you. That is what quantum merit is all about. Remember the spelling MERUIT. And then injunction, restraining a person from committing a negative act, is known as injunction. Then you have got, after injunction, you have got quantum merit, injunction and damages. So there are various damages. Liquidated damages, which are being decided before the contract is being breached. At the time of formation of the contract, the damages are already decided: 5 lakh rupees, 2 lakh rupees. These are what liquidated damages are all about, which are already prefixed. Unliquidated damages, it is not decided. It is being fixed after or calculated after the breach, and it can be of many types rather. Ordinary damages, then you've got nominal damages, remote damages, damages for repetition of contract before due date, for deterioration caused by delay, then special damages or exemplary damages. There are many kinds of damages. So you need to remember all this. In case of anticipatory breach, the aggrieved party can do two things: either he can treat the contract as anticipatory breach and sue the party for damages, or number two, he can wait till the actual date of performance. If he opts to wait, then there are two possibilities: the defaulting party may perform the contract or he may not. If he performs the contract, there is no breach. If he doesn't perform the contract, in that case it amounts to actual breach, since it is being done on the actual date of performance of the contract. And in case of actual breach, you can sue again for damages, rescind the contract and everything. That is what it is all about. Now there is a problem with waiting, in the sense that if any supervening impossibility occurs and the contract is terminated due to the fault of the aggrieved party or by an act of God or operation of law, the aggrieved party cannot sue for damages. The defaulting party is being saved in that case. So remember all these things and write it down in your own words. Basically try to write it down. I am saying all these things in this way so that you are in a position to understand that we can basically write it. So we need to understand there is a way ki don't write big paragraphs. Sometimes it happens when we are writing 3 to 4 lines at a stretch in English or 5 lines and we are not get good in expressing it, the meaning of the line is being changed and we don't even understand this thing. So your marks are being deducted and you are not being given proper marks. So in all these cases I would suggest ki what you do, you basically elaborate the things in a way of point or bullets so that you don't need to write more than 2 lines at a stretch. In that case the meaning will be intact and your problem will also be solved. So at least you will be getting some marks. Then the next important part is contingent contract. I think contingent contract and the difference between contingent and wagering contract is important. So you should know contingent contract is something which is on the happening or non-happening of a future uncertain collateral event. Wagering on the happening of a main event. Wagering is basically one person wins and the other loses. Money can flow from either side. Now in case of contingent, the money flows or the consideration flows from one party only. Wagering is always void. Contingent is valid. Wagering is a game of chance. Wagering is not a contingent is not a game of chance. So there are various differences. You can do all these things. Basically these are the important things in your Indian Contract Act, what I feel, and you can do others also, revise others, but concentrate on these particular parts. That will help you out. Thank you. And I am going to put a video for Partnership and Sale of Goods Act as well. Thank you. All the best.